Welcome to Whistle Where You Work. I'm Mark Cohen, Executive Director of the Government Accountability Project. In a bit, we'll chat with an FDA medical officer who raised safety concerns about a drug and was publicly threatened with firing by the FDA commissioner. But first, Attorney General Eric Holder has his work cut out for him, not the least in repairing a Department of Justice badly scarred under the leadership of his Bush-era predecessors, John Ashcroft and Alberto Gonzales. With us to discuss what went wrong and how to right the ship are former Assistant U.S. Attorney Melanie Sloan, who is now Executive Director of Citizens for Responsibility and Ethics in Washington Crew, and Jesselyn Radack, the former Justice Department Ethics Advisor who blew the whistle on the department's denial of the right to counsel to the so-called American Taliban, John Walker Lindh. Ms. Radack now serves as the Homeland Security Director for the Government Accountability Project. Welcome, both of you, to Whistle Where You Work.
Thanks for having us.
And Melanie, let's start with you. Why don't you lay out your bill of particulars against the Bush administration's Justice Department and what needs fixed?
Well, that's such a long list, Mark. The main problem was the over-politicization of the Justice Department on the whole. They were making decisions for political reasons and not based simply on good prosecutorial or civil litigation strategies. And that's the main thing. They brought in people who weren't necessarily competent, but who were ideologues instead. And those people often made decisions both in hiring and in making decisions about what the Justice Department would move forward based on their ideology rather than on smart prosecution.
Give me an example.
Well, we saw recently with the recently released reports from the Inspector General and the Office of Professional Responsibility about the incredible number of hiring problems. Both there was the problem in the honors program, and these are people who come to the Justice Department shortly out of law school, and they're particularly talented lawyers who you're really looking forward to having a great career at Justice, and then also lateral hires and where people were promoted and moved to. And they were making decisions saying, you should, we'll hire this person because they are a good American, or we'll make a decision because even more blatantly than that. And when a good American, by the way, was just a way to say a Republican, a conservative Republican, because it wasn't even enough to be a Republican. If you had worked for an organization like the American Constitution Society, you were completely, or if you had been a member of that society when you were in law school, you were out.
Which is a liberal legal group.
That's right, a liberal legal organization. You couldn't get a job there, whereas if you'd been a member of the much more conservative Federalist Society, you were a much stronger candidate for them. So those were some of the problems they had in their hiring. They also took people off of cases in, for example, the appellate litigation section if somebody perceived that that person was liberal without even necessarily knowing their actual politics. So that was the politicization that was such a problem in that respect. Other problems that we saw were, for example, in the U.S. attorney scandal, where so many U.S. attorneys were being asked to let go, were asked to resign, and there were 9 of those because they wanted to put in more conservative Bushies, what they used to call them.
But these were Republican appointees, weren't they?
These were Republican appointees, some of whom they just didn't think were conservative enough or who weren't towing the party line in some way. Mm-hmm. A great example of that is David Iglesias, the New Mexico U.S. attorney. Mr. Iglesias was pressured by both New Mexico Senator Pete Domenici and by Representative Heather Wilson, also of New Mexico, to prosecute a case in advance of the 2006 elections because it involved Democratic politicians, and they thought that would help them, help Republicans gain seats. And Mr. Iglesias, who should have reported the calls in the first place, did not do so, but was asked to resign because he failed to bring these indictments that he didn't think were appropriate.
Well, we have with us one of those people who came to the Justice Department as part of the honors program, Jesselyn Radack. Jesselyn, you were monitoring a kind of different part of the politicization of the Justice Department, and that is something you call burrowing. Tell me about that.
Right, that's just one of the many problematic hiring, firing, burrowing. They're all problematic employment practices that went on during the last administration. And burrowing is the last-minute transfer of people who were political appointees into career slots for which they did not have to apply, they did not have to compete, and often these slots were not even widely advertised at all, or advertised for only a week.
And so should these people be disqualified from applying for these positions?
No, no one should be disqualified from applying. The problem is what to do about the fact that they have now burrowed in to very senior six-figure plum positions and are career people. They ironically are protected by the very civil service reforms that would have prevented them from doing this.
Perhaps the portion of the Justice Department that is kind of its heart is probably not well known to the general public, but for those at the department is quite well understood as critical, because this is the organization, the Office of Legal Counsel, that guides the executive on the scope of its legal authority. Tell me about how the Office of Legal Counsel was transformed under the Bush administration and what's happening under the Obama administration.
I think under the Bush administration, rather than issuing legal advice, the Office of Legal Counsel ended up issuing legal justification. And it was writing opinions that are still secret today, basically to justify what the president wanted to do. Everything from warrantless wiretapping to torture to rendition, and all of those are part of a broad reading of executive authority during wartime, which was also opined on.
And so now the Obama administration has come in and they're attempting to clean house, presumably. What's happening at the Office of Legal Counsel?
Well, they have, I think they're in great shape. They've appointed Dawn Johnson to head that office, and David Barron underneath her, and Marty Lederman underneath her. All three of them have been very outspoken critics of the Bush administration, but specifically have opined on torture, waterboarding, warrantless wiretapping, and other programs that have been among the most controversial of the Bush administration. That is just the beginning, though. When Eric Holder says that he wants to make memos publicly available from OLC, I hope that he doesn't mean only memos from here on out. I hope he means that past memos from the last 8 years will be made public, including those that OLC may choose to rescind. I and other people would like to see the original versions of those memos.
Melanie Sloan, there certainly have been mixed signals coming from President Obama and his administration regarding whether we're going to be looking back at possible crimes of the Bush era and wrongdoing in the Justice Department. What's your take on that?
Well, he's indicated that he doesn't really want to look backward and he doesn't want to revisit many of these issues. That said, when Mr. Holder was going through his confirmation hearing, he did say he'd be willing to reconsider whether Bradley Schlossman, a former high-ranking official at the Justice Department, indeed committed perjury when he told the House and Senate that there had been no discrimination in hiring based on political affiliation. So that's one positive case. We've also learned just yesterday or earlier this week, it came out that Senator Pete Domenici is under federal investigation for his failure to be forthcoming in the case where New Mexico U.S. Attorney David Iglesias was fired.
Where it gets a little bit more hairy, I guess, is in the area of torture, rendition, in which the Office of Legal Counsel provided legal cover, essentially, for the executive to carry on policies that many people consider to be unconstitutional. What are the chances of a look back there, Jesselyn?
I hope that there will be a look back. I know that Obama has been very clear about wanting to move on and not get mired in the past, but Holder very clearly said during his confirmation that there needed to be a reckoning, and I hope that reckoning will include either a blue ribbon panel or an independent counsel or special prosecutor to seriously investigate both waterboarding, torture, rendition, and some of the more controversial programs in which laws appear to have been violated, and if prosecution is warranted, to prosecute.
And Dawn Johnson, who's the new head of the OLC, has indicated what in this regard?
She actually said, very contrary to her own interest in getting a job, but she actually said that
she
wanted to look forward, and I mean we shouldn't be too tempted to move on. That we do need to look back, and we do need to have an accounting for what happened. So I hope that will be the the position of the department as a whole, too.
Other aspects of the Justice Department during the Bush administration, the Civil Rights Division, a lot of people feel as though that its function was completely undermined. People within the department felt that. Many people left. Tell me about what's happening there.
Well, the Civil Rights Division was in fact decimated. Almost everybody left. They cleaned house entirely, and the Bush folks made it very clear they wanted everybody out. Particularly some of the things that were really troubling happened in the voting rights section, where they took positions that were contrary to long histories at the Justice Department to ensure that there was equal voting access for everybody. So there will be a serious effort, hopefully, under the new chief of the section, to revisit those cases and put back a more progressive position and protect everybody's voting rights.
To follow up on what Melanie said, to bring what she said into sharp relief, the actual numbers are that 55 to 60% or more of the career people left the Civil Division, and in the voting rights section in particular, between 2001 and 2006, there were no prosecutions at all for voter discrimination. That's the primary mission of that office. So,
should we expect, though, that when there's a Republican administration, that the Republicans' Justice Department is going to focus more on quote-unquote voter fraud, that is to keep the voter rolls thinner, because the more people that vote, the more likely it is that a Democrat's going to be elected, whereas in a Democratic administration, there's going to be a focus on ensuring that the people are enfranchised, because that will help Democrats win?
Well, the only real problem with that is that there isn't a big problem with voter fraud. Studies have shown that this is just not something that happens. While there might have been a case or two with problems, overall there are no widespread problems. And when the Republicans were making a huge issue during the last election cycle about ACORN, for example, inappropriately registering people.
ACORN being a community organization.
A community organization that was registering people to vote. The fact is they were themselves finding that people had given false names like Mary Poppins and Donald Duck, and they were tossing those registrations out themselves. So it wasn't that ACORN was deliberately trying to register people who were taking assumed names. So they were making mountains out of, they weren't even molehills, flat ground.
Okay. Any words to the wise to the Obama administration from you two close observers of the Justice Department?
Don't be too eager to look forward, because it's not my quote, Satayana actually, but if you can't remember the past, you're condemned to repeat it. And I think we need to be very careful in our national dialogue about the difference between revenge or vengeance and justice.
I think the other thing that's important is that they need to put good people in going forward, and they need not to overly politicize it in the same way that was done under the Bush years. Just because it was done before doesn't mean it's the right thing to do. And they need to make sure that going forward we have good prosecutors in the office, we have good people throughout the entire department, and that decisions are made based on the facts and the law and not on ideology.
Well, many thanks to Melanie Sloan of Crew and Jesselyn Radack of GAP for joining us to talk about what changes are needed at the Department of Justice. It's quite a list. When we return, whistleblowing at the FDA. Welcome back to Whistle Where You Work. Let's put aside the Justice Department and FEMA for a moment. Perhaps no other branch of the federal government has seen its reputation plummet in the last few years as fast and far as the FDA, the Food and Drug Administration. The agency's haplessness in protecting consumers from salmonella-tainted peanut butter is the most recent scandal, but it's just the latest in a growing catalog of public health and safety failures. Dr. David Ross is all too familiar with one of these, the approval in 2004 of an antibiotic called Ketek. Dr. Ross, now on the fact that GW Medical School, is with us. Welcome to Whistle Where You Work.
Thank you, Mark.
Tell us about your educational background and how you came to be at FDA.
I did my undergraduate work at Yale Medical School and PhD at NYU, residency at NYU, and then a fellowship in infectious diseases at Yale. And then I was on the faculty at Yale for a bit and then went to the FDA in '96.
And so tell me how you first got involved with Ketek.
Well, I was what's called a medical team leader at that point. And I had been at the agency for about 4 or 5 years. And I took over the safety review of Ketek. During the initial review cycle, new drug applications are submitted for review, and the agency has anywhere from 6 to 10 months to review them and make a decision.
So this is around 2000, 2001?
Yeah, somewhere around there.
Okay, and so and then they went to an advisory committee to see what should be done about this drug. And what happened at this advisory committee?
Well, the advisory committee was very concerned about certain safety issues, particularly involving the liver. There had been recent cases in which antibiotics had killed dozens, if not hundreds of people, especially after use for minor conditions that corrected themselves. And so people didn't want to see history repeat itself. And the advisory committee recommended that the drug manufacturer do a large safety study to see if Ketek had any risk for causing liver damage, as well as other possible side effects.
And so this study was conducted, called Study 3014, 25,000 patients. Any problems with this study?
Well, a few. The lead investigator, a woman in a small town in Alabama, enrolled over 400 patients in the study, and the vast majority of the patients were found to be fraudulently enrolled. That is, they never really got into the study, they never really received study medication, and the FDA inspected her and found that she had just made things up out of whole cloth, and she ended up serving almost 5 years in a federal penitentiary.
And was she the only bad apple in the bunch here?
No. The second largest enroller had similar problems. The third largest enroller, about 6 weeks after the study ended, had his medical license yanked on an emergency basis by the state of California, and he was arrested on cocaine and weapons possession charges.
And when FDA investigated these sites, were there any that didn't have data irregularities?
No. Every single site that was investigated had major problems.
Okay, so we're now in the end of 2002, 2003, and there's about to be another advisory committee to suggest what to do about this drug. FDA knew about data irregularities at this time?
Not just data irregularities. They knew that there was at least one. The lead investigator was facing criminal investigation, and the company claimed that they were shocked that there was anything irregular with the study.
And this would be Aventis, later to become Sanofi Aventis?
That's correct.
And so FDA, knowing that there were data irregularities and fraud at this site, they informed the advisory committee about this?
No, they did not. I emailed the FDA official who was in charge of the overall drug review and told him about the problems and said, in essence, what should we tell the advisory committee? And he responded in writing, I don't think it would be productive to tell them.
And so the advisory committee then voted to approve the drug?
That is correct.
And ultimately it was approved?
That's correct.
Did you recommend approval of Ketek?
No.
But you wrote a review that said that it could be approved, right?
Well, it was an interesting thing. My original review said that if there was additional safety data, it could be approved for serious infections such as pneumonia. I said, however, for much less serious infections such as bronchitis and sinus infections, it should not be approved even with additional safety data. My supervisor called me into her office and asked me to soften my review to, as she put it, give higher officials wiggle room.
And so did you soften your review?
Well, I did two things. I softened my official review, but I kept a copy of the original review and put it in the electronic archive.
Okay, so The drug is approved in the latter part of 2004. It's on the market for 2005. And then there began to be some adverse event reports coming in from the field. Tell me about that.
Well, there had been a report of a patient death in July of 2005. I should mention that Ketek was being widely prescribed. At its peak, a prescription was written on average throughout the country every 30 seconds around the clock, somewhere in the country. The FDA found out about a patient death due to liver damage, which was exactly the side effect we were concerned about, in somewhere around July of 2005, after the drug had been on the market for about, it was probably earlier than that. It was roughly February of 2005, after the drug had been on the market for about 7 months, but didn't say anything. In January of 2006, the Annals of Internal Medicine published a report that 3 patients at a single medical center showed up with severe liver damage after taking Ketek. One of the patients died. One of the patients needed a liver transplant in order to survive, and one survived with just supportive therapy.
And so, armed with this new data coming from the field, FDA took some action, right?
No, they did nothing.
They did nothing. And then there became news reports about this. The Wall Street Journal, the New York Times, ABC News began to report about this. Was there then action taken by FDA?
No. The FDA officials inside the agency were well aware that there were problems with the study. That was supposed to show Ketek safety. They were well aware that liver damage had been predicted as a side effect, but they continued to just study the problem. In fact, even though they knew the results from 3014, this large study, were completely unreliable, they posted it on the internet, on the FDA's website, as one of the reasons they felt comfortable approving the drug.
Well, maybe the FDA leadership thought that, yes, there are problems with this drug, but because it's so effective in treating infections, that there aren't any other drugs that can treat these sorts of infections, that we need to keep it on the market. Isn't that a possibility?
No. In fact, the studies that the agency relied on to approve Ketek did not show that Ketek was any better than any other antibiotic. They used a technique called non-inferiority study design, which shows only that Ketek is not much worse than other antibiotics. That's number one. Number two, only one of the infections that Ketek was approved for, pneumonia, is potentially life-threatening. And in fact, most of the patients treated with Ketek were not that sick. Ketek was intended for treatment of patients who could be treated safely outside the hospital. So the argument that it was intended for serious infections for which there were no other treatments simply was untrue. There were many other drugs that would do just as well as Ketek and be safer.
Fast forward to the summer of 2006, and there have been a number of news reports out. FDA leadership then announced that they were going to make some label changes to Ketek. Can you talk about that?
Sure. They announced basically what everybody knew, that Ketek carried a risk of liver damage, and they warned providers to simply ask patients if they had any history of liver disease or not prescribe it for people who had liver disease. The history of these label changes is that they are completely ineffective in changing how doctors act. And in fact, at the first advisory committee, I presented data showing that such label changes don't really work. So the solution that the agency came up with really didn't accomplish anything, but it did look like they were doing something. All
right. By this time, it seems like the leadership at FDA began to suspect that maybe you had something to do with the publishing of stories about Ketek. Mm-hmm. You were called to a meeting with other staff at FDA that were working on Ketek. You hadn't been working on this drug for over a year at this point, right?
Correct.
And the new commissioner was also at that meeting. Tell me what happened.
Well, the beginning of the meeting, it was announced that we would not be discussing any of the science around Ketek or any of the controversies around its approval. It was simply to deal with the negative publicity around Ketek. And the then acting commissioner, Andrew von Eschenbach, spoke up and said he thought everyone had done a great job, and presumably he meant concealing information about fraud from the advisory committee, failing to take action when the reports of liver damage were reported. And he then responded in terms of the reports that have been appearing in the Wall Street Journal and the New York Times and other publications, and he told people they were not to talk to about Ketek outside the agency, and that if somebody disobeyed, as he put it, the FDA is like a locker room, and according to him, and certainly this was not my experience, people could say anything they wanted without fear of reprisal. Everybody knew that was not true, but he said it. He said if you say something outside the locker room, the first time you'll be spoken to, the second time you'll be benched, and the third time you'll be traded. And it was fairly clear he was ordering people to be silent about the problems with Ketek.
All right, we only got a minute left, so tell me what's happened subsequent to that. You've left the agency.
Yes.
You've testified before Congress. You testified at a subsequent advisory committee about Ketek.
Yes.
Tell me the current status of the drug. In
early 2007, the FDA, following recommendations of a advisory committee in December 2006, removed 2 indications, something that I don't believe has ever happened before for a antibiotic. Its use has plummeted in this country. There have continued to be reports of liver damage in patients who've taken it. The individuals who failed to take action at the FDA, one individual left. One individual has actually received a promotion, as being posted abroad. No one has been disciplined for their actions or failure to take action in this episode.
In 15 seconds, do you regret having taken action yourself in bringing to light the problems with Ketek?
No, I felt it was something I had to do, and I'm glad I did it.
Okay. Well, many thanks to Dr. David Ross for discussing the troubling history of the antibiotic Ketek and for your thoughts on what it tells us about the integrity of drug companies and the drug approval process at the FDA. I'm Mark Cohen, and this has been Whistle Where You Work.